Mr. Issa, please take the floor.
The Honorable, the Chief Justice of the Republic of Kenya, the Honorable Deputy Chief Justice, and the Honorable members of this court. My name is Jotham Arua. I'm here to answer a specific question that was addressed to me by the Honorable Justice Lenaola. He had asked a question on behalf of the 4 commissioners. What were they doing at Bomas? We saw them reading some results. Was their walkout an afterthought? That's the question I will be answering, and after that I will cede the floor to my colleague Apple Lomboya, and thereafter Issa Mansour. Madam Chief Justice, the 4 commissioners have explained and clarified in their affidavits that they joined the commission in September last year. They soon found themselves having to operate in an environment in which all decisions were being made by the chair, who was operating apparently on the basis of a settled, firm, but fallacious conviction that all the executive authority of the commission reside in the chair. That heretical position was espoused in this court by none other than my teacher, Professor Gidu Migai. But my teacher, however, forgot to explain to this court the particulars of the law which vests executive authority on the chairman, but does not do so on the commissioners. Madam Chief Justice, the 4 commissioners have explained that as early as April this year, there were already protests, verbal protests being exchanged as between them and the chairman. And they have annexed a series of correspondences to that effect, which are annexed to the affidavit of Juliana Cherera, but I would leave that to be taken up by Cherera's lawyer, Mr. Apple Lomboya. Now, when they reached Bomas, they were assigned menial responsibilities, as this court has been told. Once again, there were protests, but the commissioners took the firm view that it would be responsible for them to let their infightings be made public for fear of eroding public confidence in IEBC during an election year. And it is for that reason that they chose to handle their differences diplomatically. Madam Chief Justice, these matters are contained in the affidavits. They have further clarified that although they were willing to tolerate corporate governance infractions with equanimity, they were not ready to do that with regards to serious constitutional violations. There is no doubt that they were not involved in the tallying or verification of results at Bomas. The only thing that they would do is that they would be given results sporadically at the absolute discretion of the chairman to read, which they did, sometimes with embarrassing consequences, as were explained by Paul Mwangi in the morning. But they could not stand it any longer, Madam Chief Justice, when they were now being asked to sanction results, and they were not being asked, given information that they needed before they could sanction such results. The 4 commissioners were quite clear that they had a role to play. And they were quite clear that the results would not be delivered unless and until the winner is proved to have received more than 50 plus 1%. 50% plus 1 of the votes. All they were asking for, Madam Chief Justice, was information that could satisfy them that such constitutional provisions had been complied with. But that was not forthcoming. Instead, their request was construed as an attempt to moderate the results, and that is what they could not stand. Madam Chief Justice and honorable members, at this point, allow me to call Apple Lumboya to come and explain exactly what kind of exchanges ensued earlier on between the 4 commissioners and the chairman. Thank you very much.
Your Ladyship, the Chief Justice and members of the court, the question that was asked, so that we are not accused of rehearsing a new case. The question that the court asked is that please show us that there were problems that was brewing. That is the question that the Honorable Judge, Justice Lenaola, and the Deputy Chief Justice asked. Yeah, members of the court, if you look at the 5th respondent replying affidavit, Juliana Cherera, Annexure JC2 are memos. These memos are way back from April, when the chairman unilaterally caused the reshuffling and transferring of returning officers. And just to read one of 12th April of 2022, the three commissioners, that's Juliana Cherere, Justice Nyangaya, and Francis Wanderi, says as follows, addressing the chairman: we are specifically addressing your direct role in blocking our participation in corporate decisions making on the area of policy and oversight in the context of staff deployment. In that annexure, there are several memos going back up to April. That is almost 4 or 5 months after the commissioners had joined. Because of lack of time, the only request I want to make to this court on behalf of those gallant 4 commissioners is that in your decision, you'll find a paragraph to shower accolades on these 4 commissioners for blowing the whistle to the infraction to our Constitution. And that the results that were read by the chairperson of the commission were dead on arrival. And since we have a self-confessed mortician in our midst, we will appropriately request that the funeral rites for those results that were announced be performed appropriately. I call upon my colleague, Isa Mansour, to take over.
Good afternoon, my Lady Chief Justice, the DCJ, and judges of the Supreme Court. I'll very quickly go through the remaining questions asked by the judges. The first one, I think I'll combine them, and I'll just indicate who had asked these questions. The question by Justice Lenaola, whether the violence at Bomas affected the ability to announce the results of the 27 constituencies. The simple answer is no. My Lords, the position taken by the 4 commissioners is that there was opportunity, and as has been confirmed by my colleagues from the IEBC, to deliver those results in the morning. It was not taken, and the failure to announce those results in a respectful view triggered the scuffles and the protests that you witnessed. The next question that had been asked by the Honorable Chief Justice and the Deputy Chief Justice is whether the Commission was dysfunctional, and at what point did the Commission stop functioning as a corporate entity. The simple answer has been explained by my learned seniors, but The correct position is the Commission continued acting as a corporate entity, but it had serious corporate governance issues. And this is confirmed by the fact that they were able to deliver a general election, they were able to train presiding officers, so the Commission continued working as a corporate entity with the Secretariat and the team behind it, but they had serious corporate governance issues that have played out in the proceedings before this court. The third question that has been asked by the Chief Justice is what steps were taken, and this is, you'll find in the replying affidavit of the Vice Chairperson of the Commission. As early as April, as my seniors have said, when these issues about deployment of the election managers and presiding officers was brought to the attention came to the attention of the commissioners, the matter was dealt with at plenary, and they wrote to the chairperson objecting and raising those issues and all the other issues, my Lady Chief Justice, that arose in the management of the affairs were dealt at plenary. The only problems you would note in their replying affidavits is that it's only when the chairperson took unilateral decisions in the name of the commission, that's where the problem was. And this is set out in paragraph 8 of the Deputy Vice Chairperson's replying affidavit. You'll have time to look at it. The third question, and this is a question that was not answered, was directed at the IEBC. I waited for that answer, it didn't come. I had posed it the other day. Why was the public display of results stopped? When you look at the replying affidavits of these 4 commissioners, all say the same thing. That public display was stopped by the chairperson, and they requested him to resume the display of the results, and he declined. What I was waiting for today was an answer from the chairperson as to why. That silence speaks volumes. The last question was the question that was asked by Justice, so that I can finish and give it to, by Justice Smokin Wanjala, Supreme Court Judge. Why were the numbers important? The turnout. There's a simple answer to this. The voter identification is biometric, and where that fails, it's by the kit. So, my Lord, the IEBC has a constitutional duty to put in mechanisms to ensure there's no electoral malpractice. When you go back to 138.4 to determine who has won the election, the voters that were biometrically identified, the KIMS kits are configured so that they keep sending the information, which Mahat was trying to explain today. When the numbers come in from 34As, those numbers that are finally tabulated have to, because of the biometric voter identification, they must tally with the number of people who turned out to vote. So when you're looking at those, so when they give a percentage of the number of voters who voted, and you look at the tabulation in the final from 34C, those numbers have to merge, and they have to make sense, including the from 32As. That is why the turnout is critical. It gives transparency, and it helps to give credibility to the process. And that's why they have to tell the public, you have to know how many people are registered as voters, then you know the percentage of voter turnout, you calculate that, and then you can determine how many votes were cast, how many were rejected. All those numbers, when you compute them, they have to add up. When they don't, my lords, then there's a problem with that election. Thank you, and I think I will cede the ground to Senior Counsel to close it in the next 1 minute.